Good afternoon. My name is Patricia Oviedo, and today's date, February 9th, 2023. The time, 1:46 p.m. This hearing is being held through Zoom in the matter of Elias Christopher Reese against defendant, Turlock Unified School District, a public entity, state case number CM-861717. This claim is assigned to the Stockton District Office. This hearing is being held pursuant to Labor Code Section 98, which provides that the Labor Commissioner's Office can make a determination that may become a court-enforced judgment. I'll ask each of the parties present to identify themselves, starting with the plaintiff.
Elias Ruiz.
And for the defendant?
Davis Adams on behalf of Turlock Unified School District.
And who else is present?
David Laddick, Assistant Superintendent Human Resources, Turlock Unified School District.
How do you spell your last name, sir?
Lattig.
Okay, this hearing is being recorded. First, I will administer the oath by Zoom or telephone and need confirmation of your name and agreement to provide truthful testimony during this hearing. Do you solemnly swear or affirm that the testimony that you will be giving in this matter, pending before the Labor Commissioner's Office, will be the truth, the whole truth, and nothing but the truth? Plaintiff, please provide your name, and if you agree, say I do.
Elias Ruiz, I do.
And for the defendant, Mr. Laddick?
David Laddick, Turlock Unified School District, I do.
Okay, first I will read the complaint for the record to show what the plaintiff is claiming or alleging. Then I will ask the plaintiff a few questions regarding the claim. Then the plaintiff will have the opportunity to present his claim for the record, together with any relevant documents and evidence to prove his complaint. Then the defendant will put on their case by explaining the basis of their position, giving me documents related to the complaint, and calling witnesses to testify.
Ms. Oviedo? Sorry.
Yes.
Sorry to interrupt. Just generally, can we release Miss Trevathan from standby? Mr. Laddick's here, and he's going to be speaking on behalf of the district.
Yes.
Perfect. David, can you go ahead and let Dana know then?
Yeah, I will.
And also, before we go into the hearing itself, the district would like to cover some preliminary matters that relate to the claim. Before we go on and put the entire case on, we'd like to address something, or at least put our contentions on the record, if that is okay.
Yeah, what is your side, sir?
So just to begin with, we discussed, for the record, off the record, we discussed the scope of this case. And we discussed that the scope of this case will only be related to the 4 allegations in the current complaint of WC-CM861717. Now, I bring this up because Mr. Ruiz submitted his evidence for this case under evidence for 2023-2020 or 0209 hearing, and then listed the case number. In that, he listed 52 separate allegations, 148 separate pages, approximately. We just want to make clear that as we move forward in this hearing, that we're not getting bogged down in those allegations. And Mr. Ruiz himself, in his declaration in opposition to our request for a continuance, said that it was merely resubmitted. He merely resubmitted the lengthier complaint as reference. So just want to exclude any testimony regarding any of those additional allegations and focus solely on the allegations set forth for this case.
Yeah, the only issue that we are going to hear in this matter is the issue that's on the complaint that is signed by plaintiff on November 7, and I will go on record to read that complaint for the record.
Okay, perfect. Thank you.
Okay.
Next, we have the issue that Mr. Ruiz has filed a federal complaint in this matter.
Okay, we have no jurisdiction over that, sir. I cannot hear that.
And that's precisely why I'm bringing it up. Effectively, Mr. Ruiz is requesting relief under the federal complaint, and he's requesting the similar, if not the exact same relief under this complaint.
Well, we don't have jurisdiction, like I said. We only have jurisdiction to hear the issue that's on the complaint. That's it.
Exactly, and that's why we're requesting a dismissal of this hearing, or at least a stay until the federal hearing has been concluded.
No, we have to continue with this hearing, and that's a totally separate matter. We have no jurisdiction over that matter.
Okay.
Okay, I'm going to have to interject here. You can have concurrent jurisdiction in two different venues. There's nothing wrong with that, so long as either venue has not come to a legal conclusion. If that were the case, there would be res judicata, which meaning the issue has already been adjudicated and therefore you can't bring it up in another venue. So both litigations are pending, therefore it can have concurrent jurisdiction. Now the attorney here is trying to get an advantageous position by moving this claim to the federal courts, where the rules of evidence and the procedural and civil rules are much tighter. And again, this labor commission has very lax rules. As a matter of fact, doesn't even know how to follow the rules. I don't even think this hearing officer is an attorney or was an attorney or a judge or anything like that. So he's trying to get it out from under her jurisdiction, or at least stop this from happening, because it does have the legal ramifications of a court ruling because of the authority that it's been given. But as you can see, it's going to be sloppy, and he's trying to get it out of this venue. So that's an advantageous move for him. But she could have put a stay on this, meaning stopping this jurisdiction until it went to the federal courts. I could have even asked for a stay, and then the federal court would have just used its supplemental jurisdiction to remove this portion of my federal case to the state superior court, and the superior court could have heard this because they're more familiar with the state laws than the federal case. So either way, they're just trying to get it to a more formal jurisdiction where people actually know what they're doing.
Okay, as we discussed off the record, this claim was filed originally as a request for piece rate wages.
Yeah, and let me continue because I was not done. Like I explained, I will read the complaint for the record to make sure the issue, and I will be correcting the issue for the record.
That's right. You heard her say it. She's going to correct the issue. That means she's going to try and change my claim without my consent.
And and also I just wanted to let both parties know that the hearings held pursuant to Labor Code Section 98 are not bound by formal rules of evidence. Therefore, relevant evidence will be accorded its proper weight by the hearing officer. At the end of the hearing, I will be unable to discuss the case with either party, and I just wanted to let both parties know that our decision is based upon the evidence and testimony that is taken today, as well as the applicable law.
The applicable law in this case is the Fair Labor Standards Act and the Industrial Welfare Commission Order 4, not Labor Code 2802, which is reimbursable expenses, and it doesn't apply to public entities.
Okay, let me read the complaint for the file. This claim was filed on January 10th, 2022. Plaintiff claims that he was employed by the defendant to perform personal services as a certified teacher. Is that correct, Mr. Ruiz?
Yes.
For the period August 16, 2010 and to the present. Is that correct?
That's correct.
under the terms of a written agreement. Plaintiff is claiming, on the complaint plaintiff signed on November 7, plaintiff claims piece rate wages. The issue was wrongly named, and after the claim was filed, the claim was referred to our legal unit to determine jurisdiction, and our legal unit determined that we have jurisdiction over the claim for business expenses pursuant to Labor Code Section 2802.
Okay, again, I'm going to have to interject. 2802 does not apply to public entities. This is actually Labor Code 226.2, which also may not apply specifically to public entities, but the language in that Labor Code derives from the the Fair Labor Standard Act, which is a federal law, and the Industrial Welfare Commission Order 4. They both define those as hours worked are compensatable. And because my employer made me go get COVID tested every single week, then that time is compensatable as hours worked.
So the claim should read, instead of piece rate wages, it should say reimbursable business expenses pursuant to Labor Code Section 2802 for 24 COVID screening tests at $20 per screening test in the sum of $480 less $80 paid. Plaintiff claims the amount of $400. Is this correct, Mr. Reese?
Yeah, but I would like to go on the record to state that I believe that there's still a wage claim, not just a business expense claim, because of the MOU is a contract which incorporates the Industrial Welfare Commission Order 4 and the provisions of the Federal Labor or the Fair Labor Safety Act.
Yeah, I understand, but our legal unit determined that we only have jurisdiction for the reimbursable expense, not the wages.
Well, I'm going to point out her error again. This is a wage claim, not a reimbursable expense. Her legal was wrong on this one. I did not have to pay for the test. I'm not asking to be reimbursed for anything. I'm asking for the contract language, which says I'm going to get paid $20 to go get the test, the time that I was suffered or permitted to work.
Ms. Oviedo, this actually goes to one of the preliminary matters we wanted to discuss. As you know, vast swaths of the Labor Code do not affect public agencies. They're not applicable to them, and we're not held to the majority of them. In fact, unless specifically specified in the Labor Code itself, we are not held to them as a public agency. And here, Labor Code Section 2802 does not specifically specify that public agencies are indeed held to them. Therefore, we're not.
Okay, so here's where their attorney jumps in like a fly on you-know-what and agrees with their mistake. That 2802 is what they're trying to adjudicate this on, yet it doesn't apply. The attorney's right, it doesn't apply, and that's why he wants it to get thrown out here, because it's not going to apply to reimbursable expenses. And again, this is not a reimbursable expense claim. This is a piece rate wage claim under the FLSA and IWC Order 4 and the contract language.
So while we agree that this is not piece rate, and we agree that if anything, it would be brought under this Labor Code section, the fact is we're still not held to it. And this is settled case law, and I can provide you the pin sites if you want to provide your legal department, specifically if Johnson v. Arvin Edison Water Storage District and Division of Labor Law Enforcement v. El Camino Hospital District. Both those cases specifically say that unless actually specified under the Labor Code, public agencies are not held to those sections. And as this is not a piece rate matter, as it is specifically under 02, as you just said.
Okay, but hold on. You didn't let me finish. After I read the complaint, I asked the plaintiff a question. Is this what you're claiming? And he didn't answer. Is this what you're claiming, the $400?
I'm claiming the amount of $400.
Okay. Because that's why you signed the complaint under $400, and this is the only claim that I can hear in this hearing. Anything else is not. I can only hear the issue under this complaint. Again, is this what you're claiming, the $400?
I'm claiming that I'm due $400.
Okay.
Yes.
Okay, so let's proceed.
Your Honor, as Mr. Ruiz just brought up, he's asking for interpretation of the MOU itself. And as I'm sure your legal department would also inform you that MOU interpretation is not within the purview of the Labor Commission or in its jurisdiction.
Okay, Mr. Adams, let me continue asking the plaintiff a few questions, and then you'll have all the time in the world to explain your position in the matter, okay?
Okay.
Okay, Mr. Ruiz, can you tell me, okay, I have the first date worked as August 16, 2010, correct?
That's correct.
And what was your rate of pay?
What was it back then?
No, the final rate of pay. Was it a salary, monthly, or every 2 weeks?
I'm currently employed to get paid monthly.
Monthly, okay. Okay, can you explain your case for the, how were you promised to be paid for the $20 per screening test?
Okay, so for the screening test, we were supposed to get $20 per test, and supposedly that included
For taking the test?
According to that movie, yes.
Is that when you, when did you qualify to take the test? Was it if you were having symptoms, or you were required to be testing once a week? Can you explain your case?
Yeah, so the memorandum of understanding between the district and my exclusive representative, the union, was put in place because of a health order by the state. And the state said that you had to get tested weekly.
Oh, okay.
And the only exemption to that was if you showed that you were fully vaccinated. And I never gave the district my vaccination status. Therefore, I was regarded as unvaccinated.
Okay, so you were required to test weekly.
Yes.
And you were promised to be paid under the MOU $20 per test.
Yes.
And how were you going to prove, how were they going to give you the $20? Did you have to prove with a receipt? How?
Well, they hired a third-party company to conduct the test, the screening test. And they wanted us to voluntarily sign a release of our information so that the district can receive the results of the test. Which I did not sign the indemnification and permission slip because there's a provision in there that says if there's any outside undue influence, you're signing this without any of that undue influence. Well, in the MOU itself, it says that if they don't get my results, then I could be basically fired. So there was an outside influence. I did not sign the indemnification, and the district then basically relied on me to provide them with my results.
Okay, so you claim that you were paid the amount of $80 for all the 24 tests that you took.
That is correct, because I did give them verification, 4 verifications from the company that they hired.
So they paid you once you provided verification for the $80. Did you provide verification for the rest?
No, I did not. I decided to exercise my right to privacy.
Okay, so how are you going to prove to our division that you actually took the test? What is your evidence?
So, the health order states that the district is responsible for gathering the results of the test. And they hired a third-party company to conduct these tests. They also paid for those tests. So I'm not sure where it says that. It doesn't where that I am responsible.
Well, in order to prove your case, you have to provide proof that you actually took those tests to us.
Right, but there's I could give you an excuse for not giving that.
No, there's no excuse. Either you provide the evidence or you don't.
Well, there is an excuse because I'm claiming there's a breach of contract here.
Okay, yeah, we don't deal with breach of contract.
So in a wage claim hearing, they don't deal with a breach of employment contracts? That's interesting. She also has no problem breaching the Constitution and my fundamental right to privacy by trying to allow my employer to coerce my medical protected information. Ridiculous.
That has to be done. That has to be done in court. I'm only here to hear that you're claiming that you took 24 tests and you were only paid for 80, and you're claiming the balance, the $400. So why do you have to prove your claim? It's just like claiming an expense. If you're claiming that the school district sent you to, let's say that that you have to stay overnight at a hotel, and you're claiming $400 for the hotel expense, I would ask you, can you show me a receipt to prove that you actually incurred that expense? So you don't have anything to show that you took the remaining, you're claiming that you took 24 and you were only paid for $80.
Right. And again, the agreement says that I would have to provide proof of testing unless I tested in a district-approved site, which I did test in a district-approved site.
So you felt that you did not have to provide proof?
No, because they had hired a company already who they have contracted with. They paid for the services. They have access to those records. That's more work on my part to make me go give them the results that they were ordered to get by the state.
Yeah, but that doesn't... with our office, you have to prove your case. If you bring up a case with the Labor Commissioner's office, the plaintiff has the burden of proof to prove his claim. Okay, counsel, go ahead.
So, Oviedo, I think we just hit the nail on the head here. Without any kind of verification, we don't know whether or not he took a test. We don't know whether or not he took a test at a district-verified testing site because we have zero confirmation that he did.
So again, like fly on you-know-what, this attorney jumps in and goes with her mistake, stating that I have to give and divulge my protected health information voluntarily, or at least coerced, which is extortion, to the government because they want my information. I'm sorry, I have a fundamental right to privacy, and if that's going to be breached, it needs to be for strict scrutiny. Plus, there's already there's a federal and state law which allowed the school district to get my results without my consent, and it's their responsibility to keep track of hours worked. Not mine. Go get it yourself.
Mr. Ruiz just said that we have some kind of backlog or receipt or anything. The fact is we do not have any backlog, receipt, or any verification whatsoever that Mr. Ruiz actually took the test that he's claiming that he took. I mean, this case it's really simple. Without any kind of verification, there can be no compensation. We're more than happy to pay him the $400 if he provides some kind of verification. And without that, we cannot continue. And Mr. Ruiz just brought up the MOU again, and you correctly pointed out that the Labor Commission has no jurisdiction over the MOU. In fact, if you want to seek relief from MOU provisions, the proper avenue was through the grievance process, which Mr. Ruiz himself actually pursued and was denied by the district based on his claim because, again, he failed to provide those verifications, among other reasons, and he effectively abandoned his grievance claim. Now, the whole grievance process is completely outlined through the collective bargaining agreement that Mr. Ruiz is part of. Article 11, under that collective bargaining agreement, specifically lays out the process for him to make this claim. The Labor Commission is not the proper place for this claim to be heard. That being said, the district is more than happy to pay the $400 if we have verification that Mr. Ruiz actually took the test. Fact is, we do not. So without that verification, we cannot compensate him for those tests.
So the Labor Commissioner does have jurisdiction over statutory claims. The only reason, and they do have the ability to look at the MOU and the agreement to figure out the rates. And again, they do actually have the ability to look at the MOU and the collective bargaining agreement to see what is owed.
I don't think what is owed is at issue here, Mr. Ruiz. The $20 is the rate in which you would be paid for the test if you provide verification. There's no interpretation needed to know that. You're asking the commissioner here to interpret what taken at a district site means, and whether or not you were required to provide verification because of that little clause inside of the MOU. That would require interpretation of the MOU itself, which is beyond the purview of the commission.
Okay, I think we have everything we need. And your the defendant's answer will be entered as Defendant's Exhibit A. Okay, Mr. Reese, do you have a closing statement?
Well, again, since this is an agreement for wages.
It's not wages. It is not wages. It's a reimbursable expense.
So you're telling me that IWC order saying anytime I'm suffered or permitted to work?
Sir, you're not on the complaint. It doesn't say that you're claiming wages. It's saying that you're claiming that you took 24 tests at $20 per test. That's an expense. That's not wages.
Well, again, it says piece rate wages.
It's not. It was worded wrong by the deputy that's handling the claim. It's not piece rate wages. It's a reimbursable expense. And after it was referred to our legal unit, it was determined that we have jurisdiction for the plaintiff to pursue a claim for reimbursable expenses, not for wages.
Well, my argument would be that
The definition of wages is defined as hours actually worked.
No, time suffered.
Taking
Time
taking
or
a
suffered.
taking a COVID test and getting paid by a test for a test that you took, that's an expense.
No, that's time suffered to work under the industrial wage.
That's not what you're claiming, sir. That's not what you're claiming. You're not claiming hours.
That's what I initially claimed until today when you guys switched it.
We did not switch it. It says you're claiming. You're not claiming I was under the control of the employee for 24 hours. You're claiming that you took 24 screening tests at $20 per test. Where in here does it say I worked 20 hours or 24 hours? Or I was under the control of the employer for 24 hours?
Piece rate wages from 10/9 to 10/21 through 4/20/22. Plaintiff claims the following in piece rate earnings: 24 compulsory COVID screening tests for $20
Per test.
test.
That's an expense. It doesn't say that you're claiming that you were under the control of the employer for 24 hours at your salary rate of pay. That's an expense.
It doesn't say I'm asking for $20 for the test. I didn't pay for the test. I'm not asking for reimbursement of any expense.
I just asked you if you're claiming $400.
I am claiming $400.
Okay. How did you arrive to the $400?
Because of the time that I was permitted.
How did you arrive to the $400? How did you arrive to the $400?
I'm explaining it.
Okay, go ahead.
For the time that it took me to go get these tests, to wait in line, to get that thing put in my nose, to drive from there.
That's not what it says in here, sir. It doesn't say that you're claiming minimum wage.
I'm not claiming minimum wage. I'm claiming within our contract.
What rate of pay are you claiming? How many hours and what? Well, either way, that's not what it says in here. It says that you're claiming COVID test. It doesn't say that you're claiming hours. So I can only hear what is on this complaint. And if you were originally claiming hours, our legal unit determined that we don't have jurisdiction over any hours because of the fact that that's regulated by the MOU. They said that we only have jurisdiction of the business expense under Labor Code Section 2802, and that's all I'm here to hear in this matter. Okay?
I do want to put one more thing on the record here.
I'm just going to dub over this part because she's just clicking her pen while I'm looking for some documents. Basically, the documents that I'm looking for are basically the definitions, again, of hours worked. Hours worked under federal law and under the Industrial Welfare Commission orders are any time that you are permitted or suffered to work. Whether you're producing something or not, it really makes no difference. You're under the control of the employer. You can't do something else, so they have to pay for that time.
So I'm just going to read something here. This is 29 CFR Part 78.
Does it have to do with the issue that you're claiming?
It has to do with hours worked, yeah.
Well, that's not what you're claiming on the complaint, sir. You're claiming that you took 24 COVID screening tests at $20 per test. When you signed and read this complaint and dated it, you should have informed the deputy handling the claim that you were claiming wages. But I think you were, but when it was referred to legal, they determined that we have no jurisdiction over wages.
Well, okay, let me put this on the record then.
You can put it on the record all you want, but we have no jurisdiction.
Okay, can I put this on the record and then you can make your determination?
Well, I cannot even hear that matter because of the fact that it's not on the complaint. So do you have a closing statement regarding the 24 COVID tests that you took?
Sure, I'll read my paragraph here. So 29 CFR Part 785, hours worked.
We're not here, you're not claiming hours worked, sir. You're not claiming hours worked.
This is my closing statement. Do I get to say one or not?
Okay, you can say it, but it has nothing to do with your claim.
Okay, the United States Supreme Court originally stated that employees subject to the Act must be paid for any time spent in physical or mental exertion, whether burdensome or not, controlled or required by the employer, and pursued necessarily and primarily for the benefit of the employer and his business. Tennessee Coal, Iron and Rail Company versus Muskota, Local Number 123-321, U.S. 590, 1944. Subsequently, the court ruled that there need be no exertion at all, and that all hours are hours worked which the employee is required to give his employer, employee is required to give his employer, that an employer, if he chooses, may hire a man to do nothing, or to do nothing but wait for something to happen. Refrain from other activity often is a factor of instant readiness to serve, and idleness plays a part in all employments in a standby capacity. Readiness to serve may be hired, quit, as much as service itself, and time spent lying in wait for threats to the safety of the employee's property may be treated by the parties as a benefit to the employer. Armour and Company versus Wantock 323 U.S. 126 1944, and Skidmore versus Swift 323 U.S. 134 in 1944. Actually, I'm going to skip the work week portion of that. And then I'm going to refer to one more thing. So the fact sheet for the Federal Labor, or the Fair Labor Safety Act, or Standards Act, hours worked under the Fair Labor Standards Act, There's a portion of the fact sheet that says this: employees suffered or permitted to work not requested but suffered or permitted to be performed is work time and must be paid for the employer or by the employer. For example, an employee may voluntarily continue to work at the end of a shift to finish an assignment, task, or correct errors. The reason is immaterial. The hours are worked and are compensatable.
Sir, with all due respect, I already know what the definition of hours worked means. Okay, now, counsel, do you have a closing statement?
Your Honor, like I said in my opening, regardless if we're talking about the MOU, hours work, we don't believe that this hearing right now is properly before the Labor Commission, as we don't believe the Labor Commission has jurisdiction over this hearing and the issues that Mr. Ruiz is raising. The fact is, Mr. Ruiz is requesting to be paid for something we cannot verify that he actually did. He wants us to take his word for it. He wants us to believe him. He wants us to just go along with it. The fact is, we have no idea whether or not he took these tests. We're more than happy to pay him for the tests taken, but we have no idea. We've shown our willingness to pay him the $20 for the tests taken, and I have Mr. Laddick here on standby. We can elicit testimony regarding his payment of the $20 for each and every verification that Mr. Ruiz actually submitted. The fact is, we don't have verification. We can't determine whether or not he actually took the tests, And without being able to determine whether or not he took the tests, we can't pay him. And it's as simple as that.
Okay. Thank you for the closing statement. I think we have all the information we need. Okay, then if there's no other issues, then I will render my decision, and each party will be served with a copy of our decision by first-class mail. Either party may file an appeal de novo within 10 days of service of our determination. The word de novo means that the matter will be heard again in its entirety in a court of law, where the technical and formal rules of evidence will be used. If neither party files an appeal, then our determination will be entered as a final judgment of the court and not subject to further review. Are there any questions?
No.
Then this hearing is concluded at 2:22 p.m. Thank you.
Thank you, Ms. Oviedo.
Thank you. Have a nice day, everybody.